and turn off the video when session is live. The session will be recorded and posted on our YouTube channel for our future reference. Please post your questions in the Q&A option available in the platform. I gladly welcome you all to the interactive knowledgeable session. I'm Taslima Nazreen, Executive Director of BEAM, Bureau for the Empowerment of Arbitration and Mediation, a non-profit organization in Coimbatore, Tamil Nadu. To kickstart with, let us get into the objectives of our forum, BEAM, Bureau for the Empowerment of Arbitration and Mediation. The main objectives of our forum are to create awareness among the general public and to provide training to both the legal and allied professionals, to emerge as a bridge between the government law colleges and the arbitration fraternity in imparting the contemporary knowledge, to regularly conduct continuous professional development sessions for the benefit of GLC students, to create awareness about the alternative dispute resolution, especially arbitration and mediation, to enable general public enjoy the benefit of ADR that includes MSMEs and business community overall, to foster institutional arbitration in Tier 2 cities and beyond, to regularly conduct seminars or webinars for the GLC students and industry professionals, to establish an institution that is accredited by the proposed Arbitration Council of India. Without further delay, I would like to welcome Ms. Soundarya, an Executive Director of our forum BEAM for the Empowerment of Arbitration and Mediation. Welcome, Soundarya. The screen is all yours.
Thank you, Taslima. Good evening, all. I'm Soundarya, Executive Director of BEAM. Thank you, everyone, for finding the time and attending today's webinar on the topic Drafting Skills for Legal and ADR Professionals. Legal drafting is the crystallization and expression in definitive form of a legal status of the document. Drafting is the synthesis of law and fact in a language form, and writing is like the heart of the legal profession. To simplify the same, it is the skill of drafting and the ability of an individual to express one thought process in writing. A good lawyer is one who can express his client's case most effective by way of speaking his case or the same in writing. Legal knowledge and the acumen to translate that knowledge into words are a legal professional's great asset. To deliberate the key importance of legal drafting, today we have two eminent keynote speakers with us. And it's great pleasure to introduce our speaker, Dr. S.M. Balakrishnan, who is here to brief us about drafting in legal and ADR arena, and Mrs. Hepzibah Beulah, who is an assistant professor at Dr. Ambedkar Government Law College, Pudupakkam, Chennai, who will be delivering us with the in-depth knowledge of drafting in arbitration. The inaugural keynote speaker, Dr. S.M. Balakrishnan, Principal of Government Law College, Namakkal, has been teaching law for the past 21 years and specializes in taxation law, constitutional law, international law, and interpretation of statutes. He graduated his Bachelor in Law from Government Law College, Tiruchirappalli, Master's degree from Madras University, specializing in international law and constitutional law. He was awarded PhD in law by the Tamil Nadu Dr. Ambedkar Law University for an in-depth research on the WTO dispute settlement system and compliances of its decision. He is the member of the syndicate and academic senate of the Tamil Nadu Dr. Ambedkar Law University and a member of the Tamil Nadu Legal Education Review Committee. He is an editor of Law Journal. He has judged various national and international moot court competitions. He has also published many research articles on various topics of law. Before joining the teaching profession, he has been practicing as a tax lawyer in the High Court of Judicature at Madras. Thank you for joining us on a wonderful evening, and so glad to share your rich experience and wisdom among the students and the budding professionals. Kindly welcome you to present the inaugural address. The stage is all yours, sir. Hi, sir.
Yes, thank you, Ms. Soundarya.
Yes.
It's been a great pleasure. Very rainy evening here. It's raining here in Tiruchirappalli. Rainy evening. Very good evening to each and everyone who are present here and also my colleague from Chennai, Dr. Ambedkar Government Law College, Pudupakkam, Ms. Hepzibah, and a very good evening to all the organizers, especially Ms. Soundarya, and she has taken great pains in it. It was once postponed, and now we are having it in the Anyway, I'm extremely happy to be part of this particular webinar, to inaugurate this webinar and to share my understanding of the drafting skills needed for lawyers as well as for non-lawyers for practicing in the ADR side. I will not be yes. There, yes, there will not be. I will not be taking too much of your time. I will not be eating too much. I think ma'am is having my co-speaker. She is having a PowerPoint presentations, which is a huge PowerPoint presentation. So she will be taking a lot of time. So I don't want to indulge too much into it until then. But however, I would like to inaugurate this webinar and have a keynote address with few of my understandings. See, I will not claim myself to be an expert in arbitration, but however, as a law teacher, I have attended 2 or 3 workshops, primarily the clinical legal educations for simulation exercises and for arbitration techniques in and around India. And therefore, I would like to share my knowledge of drafting skills which needed for, which is very essential for lawyers as well as for non-lawyers. So basically, coming into this seminar, as far as drafting skills is concerned, everyone has their own drafting skills. There is no problem at all. But what is needed? What is the upskilling we are needed? We are supposed to change ourselves to the modern day practices. So this is what our transitional practice. This is what we want to learn. So everyone has, the problem with us is that everyone will be having certain idea in their brain, but how to put it down in the paper, how to formulate a philosophy or formulate a doctrine, they will find it very difficult. So as far as drafting skills is concerned, I will classify into 2. Drafting skills for lawyers and drafting skills needed for non-lawyers, or non-lawyers in the sense I mean the ADR professionals, the stakeholders as far as this webinar is concerned. Non-lawyers who may be a chartered accountant, who may be a business executive, who may be a HR manager, whatever it may be. So we can basically classify the skills needed for lawyers as well as for non-lawyers. And as far as lawyers are concerned, again we can classify lawyers into 2. Litigation side lawyers and non-litigation lawyers. So litigation, will go to the courts, you're going to present your cases, you're going to draft a lot of things. If you're a high court lawyer, you'll be practicing in the writ side, you'll be practicing the second appeal. And in the year 2019, so we are at the fag end of 2020, year 2019, approximately 50% of the second appeals was dismissed by the Honorable Madras High Court, and 50%. So approximately 50% of the second appeals was dismissed by the Honorable High Court, not for want of question of law there, but purely for want of drafting skills. Because in second appeal, if you go under section 100 CPC, what is more important is that the way you draft a second appeal petition, the way you propound a question of law, because only purely based upon this question of law, a case, you can win a case or lose a case. This is the statistics as far as 2009 is concerned. I am primarily concerned with the Madras High Court and the Madurai bench of the Madras High Court, where approximately 50% of the second appeals was dismissed. So we lack certain things. That is, let us be very honest in that we lack certain drafting skills there. Of course, now it is known as the alternative dispute resolution systems. But I sincerely hope in the next 10 to 15 years, it will probably become the mainstream dispute resolution system, and the court cases will go for alternative dispute resolution system. Because of the docket explosion, everyone knows that what is the time taken by, I still remember a case filed in 1974 in Madurai District Court for partition suit. It is still pending in the Madurai, is still pending. The second appeal stage. See, 1974, all the plaintiffs has passed away, all the defendants has passed away, the legal representatives are fighting their cases there. So because of this docket explosion, naturally, we tend to go for alternate dispute resolutions, especially in dealing with contracts and dealing with even for matrimonial disputes in this. And I sincerely hope in the next 10 to 15 years, this will become a mainstream dispute resolution, and the court cases will go for an alternative dispute resolution. The courts will become alternative dispute resolution. We should have that. That should be available, because excessive docket explosions there. Right. I would give a brief understanding about, or what are the upskills needed, what is upskill needed to improve our drafting skills, or what are the traits for a good lawyer or a good ADR professional. This is what I want to discuss. What are the good traits for good lawyers? See, everyone is a good lawyer. Everyone has a. At the point number one, I would like to discuss something about an Italian mathematician by name Wilfred Pareto. Most of you might not have heard of him, but very few might have heard of him by name Wilfred Pareto. You can go there and you can search the net. He is an Italian mathematician. He is taking certain things into considerations and goes for analysis there. And he propounds the 20-80 rule. 20%, 20:80 rule. So this is what known as 20-80 rule. If you go to Google there and search for 20-80 rule, you can this. What is this 20-80 rule? What is this 20% to 80% rule? See, he takes certain the practicing lawyers into consideration. He takes certain musicians into consideration. He goes for an analysis, and at the end of his research, what he finds is that 80% of the work goes to 20% of the lawyers, and 20% of the work goes to 80% of the lawyers. So the thing is that only 20% of the lawyers are dealing with 80% of the cases, and the rest 20% is left to these 80% lawyers. So we can, from this we can analyze that the better the lawyers, the better the skills, the better the cases, therefore they are proportional to each other. So where a lawyer is skillful, where a professional is skillful, naturally you are having more number of cases or more number of clients to him. This is what Wilfred Pareto, after a long research, was known as the 20-80 rule. So 80% of the cases will go to 20% of the lawyers, and this you can verify it in your own city. If you take Coimbatore, yeah, that is the case anywhere in India. Nearly 80% of the cases go to the only 20% of lawyers. So what makes the difference? Why we go to this 20% of? So it is time to decide whether we want to be in this 20% or we want to be in this 80%. If you want to be in this 20% bracket, naturally we have to make certain skill developments. Naturally we have to improve our trades. So that is what a basic understanding which I would like to share with you. You can go and you can check for Wilfred Pareto, an Italian mathematician there, the 20-80 rule. That is very, very important as far as we are concerned. So we should be very pragmatic in approach. We should understand, or we should take into consideration, or we should self-introspect at what are the things which we are lacking. Everyone is not a good lawyer, but we can become a good lawyer. We can become a good professional only by improving ourselves there. So with this 80-20 rule, I would again go to another rule there, which I normally used to tell my students in various government law colleges. I also used to tell in many webinars which I have participated there, what is known as the 1 hour rule. Many of my students will be knowing that. The 1 hour rule by Jim Cathcart. Again, you can go YouTube there. You can go to YouTube. You can see the Jim Cathcart. See, Jim Cathcart is a person. He's a personality development official of the United States Army. See, he basically says about the 1 hour rule, which is very, very important for a professional like us. Practicing 1 hour of deliberate practice. What is known as 1 hour deliberate practice rule? This is what he says, that 1 hour deliberate practice rule. You are supposed to deliberately practice, whatever might be the situations. Deliberately, you have to practice certain things. If you want to be a good lawyer, you have to improve your drafting skills. Definitely, you have to draft at least certain things 1 hour per day. At least you have to read some things. When you want to become a good orator, you have to read at least 1 hour per day. 1 hour per day for 5 days for the next 5 years you will become a great orator. You will become a great person in that particular chosen field. You can be a master in that particular field. This is what he says, that it is not a difficult one. It's a very, very simple one, which has been this particular rule has been spoken of highly by the United States swimmer Michael Phelps. Mark Spitz got 17 gold medals. He applied this 1 hour per day principle for 365 days, of course, barring Saturdays and Sundays, and he got 17 gold medals. So I want to get more gold medals. You know, Michael Phelps, the greatest swimmer of all times, the American swimmer. I want to go. Therefore, he started practicing for 7 days, 1 hour for 7 days, and all the 365 days, and now he has become a champion. So this 1 hour of deliberate practice, I would like to suggest to all the professionals, all the law students, and all the lawyers, and all the other ADR professionals to go for a deliberate practice of 1 hour and follow Jim Cathcart method, or you can also have your own design, your own methods there. What is important is that if you want to have a good drafting skills, you should deliberately practice for 1 hour, whatever it may be. It may be a plaint, it may be a return statement, it may be an award. You may not be an arbitrator, but still you can draft your own arbitration, you can draft your own award, so that you can improve upon this award. So this is what the preliminary messages I want. Like, you take into consideration the Wilfred Pareto methodology, you take into consideration the Jim Cathcart methodology, and then the third one, I would request all the lawyers, all the law students, and all the professionals here to go for SWOT analysis every year. I think most of you might be knowing about SWOT analysis, SWOT, SWOT analysis, which is very common now in the business communities there. The business professionals are also here, I think. It is very common in business communities here. Strengths, weaknesses, opportunities, and threats. So this is the SWOT analysis. Every lawyer or everyone who want to come up in their life, want to be an expert in their life, in the chosen field, they have to go for SWOT analysis, at least for every year. What is SWOT analysis? Nothing but going for a self-introspection. You self-introspecting, where I am today, where I will be in 2022, where I will be there in 2025. This is what is known as SWOT. The great thing about SWOT analysis is that most of you might not be knowing that the father of SWOT analysis, Thiruvalluvar. That is something new to many of this. So being Tamils, we should be very proud of that. The father of SWOT analysis is Thiruvalluvar. It will be very amazing to know that Thiruvalluvar, some 2,500 years before, was the first person to introduce, to conceptualize what is known as SWOT analysis in modern day times. If I am permitted to say that, I will say it in Tamil. I think many non-Tamilians are also here, but let me explain it. One particular couplet from Tirukkural is nothing but SWOT analysis, right? What they think. Vinay valiyum, tan valiyum, matran valiyum, tunai valiyum, thuki chel. This is what Thiruvalluvar says. Vinay vali. What is meant by that? What is the nature of work you are going to do? Tan valiyum. What is your strengths? What is your strengths? Matran valiyum. What is meant by that? Your opponent, or your enemy, or your competitor, whatever may be, what is his strengths? Tunai valiyum. What is that? The ability to take friends, the ability to gather knowledge from your friends who are supporting your cause. Tunai valiyum, thuki chel. You analyze all these things and then enter into that particular. So this is what a message I would like, Thiruvalluvar's message, what got translated into SWOT analysis. And we are supposed to, now in the business community, in army and in business, people used to go for SWOT analysis. Every company has a SWOT analysis team. They will go for what are these opportunities. And I would like to suggest that even lawyers, even ADR professionals, even law students, everyone should go for. So what will be our target? So these are the basic things I would like to suggest that you should always go for a SWOT analysis. You can try to improve upon that. You have to see a goal without a deadline is you will fritter away. That is what people used to say. There should be a goal with a deadline. So that is what a goal is also about. So what we are going to do in 2 years down the line, in 5 years down the line, that is what is known as goal setting in common parlance. People used to call as goal setting. So this is what I would, are these preliminary things which I would like to suggest for the members present here, the audience present here. Always go for SWOT analysis. The fourth point I would like to suggest is that whatever it may be, whether it is in English or is in your vernacular languages. See, now you can see most of the companies, most of the contracts, most of the real estate contracts, most of the marriage disputes, divorce disputes, they go for arbitration, alternate dispute resolution, because it is cost effective rather than going for a court settlement, which is very expensive in India, and it takes a lot of time. This principle they have developed in the United States. United States has a wonderful ADR regime. In many European countries, Nordic countries, they are having wonderful ADR regime. In fact, if you go to United States of America, their lawyers can advertise themselves. Their lawyers can advertise. Here it is not possible. They can advertise. If you go to New York Times Square, you can see in the Times Square where there will be an electronic billboard will be running the lawyers advertising them. This first 1 hour is free. Next 1 hour, every hour you will be charged $90. This is what. You can also see some tongue-in-cheek advertisements also. One nice advertisement is that life is short. Get a divorce. Approach us. This is the billboard which is running there in the United States. Life is short. Get a divorce. Approaches. Melanie and Griffith LLP, attorneys and arbitrators. So this is the advertisement there. The irony is that the partners, the LLP, Melanie and Griffith, happens to be husband and wife for past 30 years, and they are saying life is short. Get a divorce, approaches. A tongue-in-cheek advertisements. You can see a lot of these things there. So that is they have gone to that extent there, but it is also expensive there in the United States. Unlike our arbitration procedures, because if in a matrimonial dispute, if you go for an arbitration, you have to pay the fees for the lawyer, you have to pay the fees for the arbitrator. Then you should necessarily have a child consultant with you. There should be a child, which is not there in India. I have a child consultant there, and if you are having parents, then you have an aged parent consultant there. Then you also should have an account that we have to pay for all these persons. So it is also expensive there in the United States. But when it comes to court cases, it will take around $25,000 to $30,000, whereas this will come to around $6,000 to $8,000, and therefore people divorce settlements, they are going for arbitration settlements there. See, ever since most of the students who have studied international law, they will be knowing about this particular case, the case between the United States versus Canada, what is popularly known as the trial smelter arbitration case. In fact, that was the triggering point for many arbitration disputes later. Instead of going for court cases, we'll go for arbitration. Students who have studied international law might be knowing that particular case. The trial smelter arbitration is a case between Canada and USA, where Canada, in the city of Trail, there are a lot of smeltering plants, like copper smeltering plants, lead smeltering plants there. They used to send their effluents without effluent treatment plants. They used to discharge those effluents into River Columbia. River Columbia, it crosses United States, and it reaches and it empties in the Lake Superior. So River Columbia does not discharges into the sea. It discharges its waters into Lake Superior, and Lake Superior provides nearly potable drinking water for nearly 40% of the Americans. So all the Americans, therefore a tortious liability was preferred. It's a purely a tortious liability, and as far as my knowledge goes, this is the first mass tort action which we can find it in our Bhopal gas disaster case also. The first case where instead of going to the ICJ, or instead of going to the Canadian court, or instead of going to the American Supreme Court, they appointed William Taft as an administrator there. William Taft, as you know, he later became the president of the United States of America. William Taft, and they went for an arbitration settlements there. Probably that was the first mass tort action which went for an arbitration settlement, and that is one of the triggering points for modern arbitrations. I have the UN Citral courts, all those things there. So I would like to suggest that before actually venturing into this particular field, we have to equip ourselves. We have to equip ourselves in the sense we have to go for lot of legal research. And research is very, very important. Students who are participating in the moot court will be very, very thorough with this type of research. They will be preparing these memorials. What is this? What is the statement of claim? What is this statement of defense in an arbitration proceeding? It is primarily a moot court memorial. What we students used to, what students of colleges used to prepare. If the students are well versed in moot court practices, then definitely it will be easy for them, because where they can improve their research skills, they can have their interpersonal skills, they can improve their advocacy skills. So what is known as clinical legal education? Of course, in government law colleges, we have the clinical legal education program there, but I don't think it is implemented properly because of the simple reason, because we are having too many, the strength of the students is too much. We are unable to bear this. So it will be very, very difficult to implement that. This is problem with any, in all government law colleges there. Of course, there will be some difference of opinions there, but still, I would say that because of instead of going for quality legal education, we are going for mass legal education, and therefore we will have too many. The strength is too much, and therefore it is very, very difficult to implement those things. What is very important is that these institutions like Beam, I think Law Seco is doing that. Law Seco is a website, .com, a website, is they are doing these particular practices there. What we need is that actual learning environment, which is very, very difficult there. See, unless and until you want to become a very good professional or a very good lawyer, every law student go for an actual, or we should go for a real working environment. So how can you get this real working environment? So only when you go for case studies, when you go for in-depth legal research, only when you go for simulation exercises. You students, the students themselves can, I am implementing here in Government Law College Namakkal, I have implemented that in Trichy and as well as in the students themselves, instead of regular moot courts, you can give them an arbitration case. So a dispute between the Indian team, cricket team, versus the Board of Control for Cricket in India regarding advertisement rights. Every player will be having a lot of advertisements in the battle. This is an arbitration dispute which actually happened there. So this as a case study, we can give it to students. We can divide them into two branches, one for the claimants and another for the defense, and therefore we can go for certain simulation exercises there. So simulation exercise, by simulations mean we are giving certain real problems or hypothetical problems to them and asking them to prepare their briefs. So thereby you can improve their advocacy skills, you can improve their interpersonal skills, you can improve their drafting skills. That is very, very important. You can improve their drafting skills there. See, by drafting skills, we all at the first place, when I asked to write certain things, we will write it for 3 pages. Then after that, we have to chisel out certain things. What in Western world they call it as white glove editing. It's nothing but you are chiseling out certain unwanted things. In the Americans used to call it as white glove editing. And what is that? You are writing certain thing, then you have to edit it. What are the necessary words there? What are the unnecessary words there? You have to chisel it. You have to reduce it to 1.5 pages. Then actually you will reduce it to 1 page. So what you have written in 3 pages, you can convey it in 1 page. So that can be done only by deliberate practice. That is what I used to say about Jim Cathcart. That can be done only by deliberate practice. So by doing a deliberate practice, you can reduce, there can be economy of words there, whether it is in English or it in your vernacular languages. I see in government of Tamil Nadu, many contracts signed by the government, it is in Tamil. And most of the contracts, they are having a separate, right now, after 2000, we are having arbitration clauses in government contracts or arbitration agreements in government contracts in Tamil. And I'm equally sure it will be there in other vernacular language in other states also. In Tamil Nadu, it is there. The contract by the government is in Tamil, in chaste Tamil, and they will go for an arbitration clause there. Of late, they are in PWD contracts, in highways contracts, they are having an arbitration clause there. Now it is evident it is in Tamil. So therefore, when you want to become a good ADR professional, you should not only be thorough in English, because most of the contracts are signed in English, but the day will come where you should also be thorough in your vernacular, in your mother tongue, because in the course of time, of course, in international contracts we are having things, But in the course of times, when our client happens to be governments, when a high client happens to be a government contractor, then naturally we are supposed to be thorough with our lingua franca also. Because if you see in most of the contracts, we can see contracts entered in Tamil, and we are having. I'm sure that will be the case in everywhere. So the best thing to avoid is that normally there are certain things in English what people used to say as jargons, legal jargons, what people used to say as rhetorical flourishes, people used to say as euphemisms. We are supposed to avoid these jargons, these euphemisms and rhetorical flourishes in drafting. So that is in a different field there, that is for literature there. By jargons, see, you may be thorough with certain legal jargons, you may be thorough with certain legalese, but not your clients. So we are here for the clients, and therefore the drafting, you should even the client should understand what you have drafted. So it is better to avoid certain jargons. Of course, in legal profession, of course, in legal drafting, we can have certain legal jargons. We can use certain words there. We can use lot of flirting words, sui generis. You have umbrima fide. What is the? But these things, your client will not be in a position to understand or comprehend these things. So it is better to avoid certain jargons, euphemisms. Euphemisms, what means it is in a different realm. You are telling something which is in a polite way rather than in a harsh way. Instead of saying he is a disabled person, you can say it as physically challenged. But that is there in a different realm. But as far as practice is concerned, if he is disabled, you please straight away say he is disabled. There is nothing wrong in that. Let us call a spade a spade. That is what we want. So that is our drafting skills. Please avoid and rhetorical flourishes. See, rhetorical flourishes by being what you want to say, we can reduce it. We are going beyond to the realm of philosophy. We are not supposed to speak philosophy here. We are having no philosophical murings here. We are straight up to the case here. So when we reduce these, when we chisel out these things, what we will get is a beautifully drafted plaint or a beautifully drafted return statement or a beautifully drafted arbitration clause and arbitration accord, arbitration agreement. Or if you are an arbitrator, you can draft a beautiful arbitration award. As you all know, in the arbitration accord, the question of stare decisis does not arise. There is no stare decisis as far as an arbitration award is concerned. The only in course we are going to use the stare decisis principle. We are going to use the doctrine of stare decisis. As far as arbitration awards is concerned, you are completely bereft of stare decisis principle. Therefore, you can have your own thing. What is very, very important is that we have to chisel out certain things and you have to draft things accordingly. You have to go from there. If you are going for a statement of claim, see, in some arbitration disputes, they will first have a notice of arbitration. But in most of the international arbitrations, they will send notice of arbitration and statement of claims together. And then they will have a statement of defense by the respondent parties, and then they will go for an arbitration there. And the principles changes from country to country there. But in India, as far as India is concerned, and if I'm right, first used to send a notice of arbitration, then you go for a statement of claims, and then we go for a statement of defense, and then we go for an interim award, and then we go for a final arbitration award. This is the procedure we are following it. Though the UN Central Court says that we can straight away go for notice of arbitration, statement of claims together, especially post Sanyong case there. Sanyong case is a very, very important landmark decision as far as our ADR principles are concerned. We are supposed to do these things in there. What are the things which we have to avoid? What are things which we have to avoid, or what are the pitfalls in our in improving our skills? What are the pitfalls there? As I said that we will primarily go for euphemisms, legal jargons. Please try to avoid those things. That is the first message I would like, and this is the pitfalls I would like to. We generally used to do it. Generally, we used to do it. We will be a very good orator in English. We will be a good orator in Tamil. But how to put it down in writing, that will be a very difficult one. I'm damn sure that what is there in your mind in thought process cannot be translated. That is the difficulty most of us will be facing there. Very few they can put it down in paper, what is their thought process, what is that, with clarity of thought. But most of them, they will find it difficult to put it down in paper. That is the difficulty which you are going to get over that. And by getting it over, we do not have a specific formula. We have to improve ourselves day by day. At least for a period of another 1 year or 2 years, we can be in a different realm altogether in drafting certain techniques there. And very importantly, normally in court proceedings, we go by passive voice. Instead of using I consider, we use the word it is considered. Whereas these things, as far as arbitration proceedings are concerned, it is advisable not to use passive voices. Instead of that, you can use active voice straight away. I consider. That's all. You please do not use it is considered. Why you go for something that is not. Most of, if you see most of the arbitration awards in foreign countries, it will be very, very simple and very, very crystal clear. They will use active voices rather than passive voices there. And very importantly, and what I would like to suggest is that instead of using this word, in my opinion, normally you can see in the awards which is given here, we use the word in my opinion. There is no question of opinion in an arbitration award. I determine. This is what, yes, instead of using the word opinion, let us use the word I determine. This is what I'm going to determine. I determine an award that the respondent shall pay, or not may, shall pay a compensation of this amount. Let us straight away come to this now. In my opinion, don't use the word opinion. I determine. So let us always be in the active voice rather than being passive voice. Normally in court proceedings, we used to do that. Even judgments, they used to, in my opinion, this. There is no question of opinion there. Unless and until you are going for opinion of the Supreme Court, where the President of India has sought opinion of the Supreme Court, you can give an opinion. But where there is a case there, you can straight away say, I determine. This is the facts of the case. This is the factual matrix of the case. This is the legal principles which are involved. Therefore, I determine this. And this is. So let us always use the word shall instead of may. Let us always be in active voice rather than having a passive voice there. There are umpteen number of examples which we can give that. The only thing is that we should go for daily practices and update our knowledge. Updating our knowledge is very, very important. Again, updating is very, very important. Over a period of time, we tend to lose interest, or we fail to update our knowledge. But I would like to suggest that even as per Jim Cathcart, or even as per our at least 1 hour of deliberate reading is very, very important there. In the chosen field, you are supposed to read certain things there. Whatever might be the circumstances, I am practicing it, and therefore I have every right to say that every day at least 1 hour of deliberate reading or deliberate writing is a must to become what you are now. Next 5 years, you will become a master in the chosen field there. You may be in commercial arbitration. You may be in you may be a litigant side lawyer there. Whatever it may be, in the next 5 years down the line, you will become a master. And above all that, extreme self-confidence is what is your inner confidence? Right now though many will be low in their confidence. What I am going to do after completing my law degree, what I am going to do there will be a big moot point or big question between them. And do not worry all those things. Do not worry about all those things. You start right now. The next 5 years down the line, you will be getting immense self-confidence. What is very, very important is that in self-belief and self-confidence, which will crack anything. Immense self-confidence and self-belief will take you to a different level altogether there. I think I am not taking too much of time. Ma'am is also waiting there, and ma'am, I think she will be taking. I think you are having more than 20 slides, ma'am. I think it will be taking a lot of time then. And even I am also having. I have already told Ms. Soundarya. And with this short message, I would like to wind up this particular session, and I would like to inaugurate this webinar and better better skills. Young minds will always have a better, and Hepzibah ma'am is there. As the saying goes, new brooms will sweep well. Of course, but the old brooms know the rooms better. As the going is I will not be there for the full session there. Let me take leave of you. Anyway, once again, I would like to thank all the organizers, Ms. Soundarya, Ms. Madhumitra, and Mr. Ramasubramaniam, and all others there. And if time permits, on some other occasions, we will have some other discussions on various other topics of law, on various other topics. Once again, I would like to congratulate the institution there. And I think it's a non-profit institution. What Ms. Soundarya said.
Yes, sir.
Soundarya is in Chile. You please try to go for simulation exercises even among students there. After class hours, you can go for simulation exercises there. If you want to have a lot of problems there, I will send you a lot of problems there where you can give it to your students. You can discuss. You can bifurcate the students into 2 groups there, and then ask them to prepare a brief, and then ask them to go for good mediators. I think most of you might be knowing about client counseling. Client counseling is a very, very important aspect for ADR professionals there. Many lawyers will not be going for practice sometimes, and there will be non-practicing lawyers there. So they will be ADR professionals, they will be consultants, they will be simply they will be drafting certain documents, whatever it may be. In all cases there, drafting is very, very important. What is your thought process and how you are going to put it down in writing is very, very important. You can always go for simulation exercises. I am requesting the institution to go for simulation exercises. You can give them problems. You can give them, be an arbitrator. You sit as an arbitrator, or you can have 3 arbitrators there. You have an arbitral proceeding. Then ask the students to prepare a brief and present their cases. They will be wrong. Most of them will. What is the biggest problem in us, in students, which I find, is that inhibitions. So the inhibitions, first leave all those inhibitions. You prepare a brief. Only by regular simulation exercises and research, we can go to the next level. Unless and until we are thinking of next level, we can never improve ourselves. So always apply the principle of Jim Cathcart. We apply the principle of SWOT analysis, and always apply the principle and always think of Wilfred Pareto of the 2080 rule. And naturally, now you will be in the 80% bracket. Tomorrow you will be in the 20% bracket. With this note, I would like to thank all the organizers once again. Thank you so much, and thank you, ma'am. Ma'am, I'm extremely sorry. I will not be available to see your session.
Not at all a problem. It is in the hands of the opening batsman always.
Yes, I'll not be there.
Thank you so much. Thank you so much.
Yes, I will call you later, ma'am. Thank you so much. Thank you, ma'am. Thank you.
Thank you, sir.
Thank you so much, sir, for your enlightened thoughts and so many valuable inputs to the students like me who are just beginning their career in the field of law. Okay, all right. Now I invite my colleague Madhumitra, who is an executive director of B, to take over the session. Welcome, Madhu.
Thank you, Soundarya. Our next speaker is Mrs. Hepzibah Beulah. She is an assistant professor at the Chennai Dr. Ambedkar Government Law College in Pudupakkam. She completed a master's in labor and administrative law from the same institution. She is also pursuing a doctoral degree. from the Tamil Nadu Dr. Ambedkar Law University. Her specialization includes administrative law, labor law, taxation law, alternative dispute resolution, and remote sensing laws. She has practiced in various courts in Chennai for a span of 2 years in the field of corporate, labor, arbitration, and IPR laws. Later, she began a corporate journey with MNCs, which include Standard Chartered Bank, followed by a Hong Kong and Shanghai Corporation Private Limited. She is a member of Young Singapore International Arbitration Center and Space Generation Advisory Council. Recently, she has been selected as a pro bono researcher and chairperson of Remote Sensing Legal Task Force by the International Academy of Space Law, Moscow. Ma'am, the screen is all yours.
Thank you so much, Madhu. Thank you, Bala sir. It's not there. I hope there's no disturbance. Okay, thank you, Bala sir. As I said earlier, it's all in the hands of the opening batsman. He's actually taken a great weight off my shoulders. I don't have to talk much about legal. And going through the participants, I understand most of you are from construction industry or some industry or corporate because your background, and I can see from that. So I'll stick on to drafting with regard to ADR, and I will not dwell too much into legal part. Okay, because students, they know they are with us, so we can teach them anytime. But since a lot of professionals are here, so I'll stick on to the main part of drafting. All right, and about my introduction, yes, I started my career as a legal professional. I worked as a junior, let me just present it. All right, I started my career as a junior legal associate in King & Partridge law firm. It's a law firm where there are a lot of arbitration cases those days between 2005 2007. So that is where I learned arbitration. But above all, I should say, I learned drafting from my senior in King & Partridge. So he had 50 years of bar experience. So that was very good ground for me to learn. And that helped me a lot. After that, I was working for 5 years in the banking industry. So even when you move out to any place, be it teaching profession or you move out to a corporate, wherever you go, your drafting skills speaks a lot. It matters a lot. So that is how you get closer to people and people recognize you. Right. So that is one thing I want to share with you. So you have to improve when you improve your drafting skills, you start shining in your profession. That is what happened to me. So I will give you some tips on how to do that. And before that, I want to tell you, this is the PPT I'm going to share. It started with 5 slides, and then they wanted more, and then it came to around 30 slides, but I will not speak a lot, and every slide will be less than 5 minutes. So don't worry, I'll finish off as fast as I can. All right, and I will also be sharing the PPT, so don't worry, you don't have to take notes unless I'm telling something which is not in the PPT. All right. So coming to I can't see any of your faces. In case I'm out of sync, just call me, or Madhu, you can interrupt me anytime. All right, so coming to the first slide, which is the topic, drafting skills for legal and ADR professionals. So the first part, drafting skills for legal professionals, almost Sir has covered, so I don't have to get into it. For ADR professionals, so the word term ADR, when we take, it includes everything. Negotiation, mediation, arbitration, everything is included. So, but if we take negotiation and mediation, the paperwork is very little compared to arbitration. Because in arbitration, you have a lot of paperwork to do, a lot of drafting work to do, and you will have to establish what type of drafting has to do for different things. So initially, you'll be drafting for agreements and clauses, and finally, you'll be drafting for, even if you're not drafting, the lawyers will provide you documents which are legal documents. So you will be in a position to understand those documents and then interpret it. Suppose you're in the mid-level and you have to explain to your manager or to someone at the top level, then you should first of all understand what is there in the document, and you should be able to explain to them. Before even drafting an arbitration clause or an arbitration agreement, you should be in a position to first of all explain to your boss, your manager, your top level management. You have to explain to them which is best, which can be used in your agreement. All right, so that is where we're going to start, and this is a simple introduction about arbitration for all of us are there. No? Lawyers are there, students are there, from industry we have people. So I just go give a brief introduction about arbitration. So what is arbitration is like when you have some dispute, a controversy or claim, a dispute, we approach court, right? So in 1976, yes.
Your PPT is not visible, it seems. Ma'am, can you please present again?
Can you see it, Madhu?
Yes, ma'am, I can, but some attendee could not.
I'll do it again, no problem.
Yes, sorry, ma'am, sorry.
No problem. In Google, it takes some time to stop and then restart. Is it visible now?
No, ma'am. No, ma'am.
Not to anyone?
No, ma'am.
Not visible, ma'am.
Can somebody help me? Sanofer, can you help me, please?
Yes, ma'am. I'll do it.
We will present it now.
Yes, no problem. Morning it was visible. I don't know what's the issue here. You have the recent one, no, Sanafar?
Yes, ma'am.
Yeah, please help me. So I'll just continue. So arbitration is nothing but instead of going to court, you have a third party who will be handling it. So third party is a person who you will be deciding, you will be choosing. It's not like court where it gets listed and you don't even know who's going to be the judge. It's not like that. So suppose there's a dispute between party A and party B, and party A, what does he do? He appoints one arbitrator. Party B, he appoints another arbitrator. And these two arbitrators, they will appoint another arbitrator who will be like an umpire. So all these three people together, they will decide on your case. So this is all about arbitration, as simple as that. So to help you with drafting, to help you with the entire proceeding, we have something called arbitral institutions. We have, for example, SIAC or HKIAC. There are a number of institutions who help you with this entire proceedings, because there are people from industry who don't know how to proceed. So to help you out, and they also have some rules to be followed. So when you follow that rules and when you adhere to them, they will help you out to complete the entire process of this arbitral proceedings. So apart from that, is the slide ready?
Yes, ma'am. I'm presenting now.
You're presenting. I think there's some problem. I'm extremely sorry for the issue that's going on.
No problem, ma'am. We can proceed, ma'am. No problem.
No problem. Okay. So for this, the entire process, if you see, first we will file a claim. Then claim is nothing but the claimant, who is party A. For example, party A, he will file a claim, and then he'll send a notice to the other party. That person will reply. That person is called the respondent. He will answer back. And then what these both two will sit together and do is they will appoint an arbitrator. So the appointment of arbitrator is followed by, you will schedule a meeting. You schedule a meeting, a hearing, then you will discover what are the documents available. You sit together and talk about the documents. And then finally you go for a hearing. And after the hearing, the decision is given. In normal case, decisions are called judgments. In arbitration, we call it award. That's the only difference. All right. So now you would have, nice. Now it's getting shared. Can you share the second one? So that's the roadmap. Second one, the before one. One before. Yes. Okay, that's the entire process of how an arbitration takes place. But now coming to drafting, what are the things, topics covered? What are the things we are going to learn in this session is, first thing we learn about drafting an arbitration clause. After arbitration clause, we proceed to learn about arbitration agreement. These two will look similar for people from the industry, but people from the legal background, from law students, they might know the difference between a clause and an agreement. All right, a clause is nothing but you have a main contract. Suppose party A and party B entered into some job, they want to do some work together, they want to do some project together. So they enter into a main contract. So in that main contract, if you are going to draft a single clause in that saying that you will be going to arbitration, that is called as an arbitration clause, right? The next slide is an offer. And then after that, we will move to arbitration agreement. Agreement is nothing but it is a standalone document. It is not like a part of your main contract. It is a standalone agreement. So you will be drafting an agreement, the whole agreement together. It will have all the specifics, all the information, detailed descriptions. So this is not as short like an arbitration clause. So you need to know in detail what are the things you have to include in an agreement. Followed by that, we'll talk about a notice for appointment of an arbitrator again. Before that, we will talk about some deadly sins which you should avoid while drafting. Then statement of claim and defense is something I will not dwell in detail because it's more of a legal, because people from law background, they know to draft a plaint. So when you know to draft a plaint, you should also be knowing to draft a statement of claim and defense. What a statement of claim and defense is nothing but I, party A, I'm claiming something against party B. So what I will do, I will draft a complaint. That complaint is nothing but a statement of claim. In normal parlance, normal or we call it as complaint, right? The same way it is called statement of claim. And for my statement of claim, there's another party B who is going to reply back to me. That reply is called as a statement of defense. All right. So after that, interim applications during arbitration proceedings. So once arbitration proceedings have started and it is going on, you want some interim relief. As a property which you want to preserve, or you want to enter into someone's premises, you want to do something with the property. All of that, for all of that, you have to apply to the court and ask for an interim relief. All right. So that part, and after that, we'll talk about execution application. Execution application is the last part. An arbitral award has been passed. And after arbitral award has been passed, we have to execute it. So to execute it, an execution application is being filed. So again, we will talk about how to draft an execution application. So the last three, leave the arbitration award, statement of claim and defense, interim application, drafting and execution application is all related to lawyers. Anyway, even if you're in industry, you're going to involve a lawyer and you're going to do it. But still we talk about it. Even though you're from the industry, you should know where a lawyer makes mistake. So if you need to understand, you have to become a lawyer. Once you become a lawyer, you can easily find out where they miss out. All right. So these are all the topics we'll be covering today. Next slide, Sanofa. So I'll just give you a roadmap of what we'll be doing. The first thing is I was talking about arbitration clause. See, arbitration clause, I said, is just one paragraph or two paragraphs, but it is like an atom bomb. You miss out something, it's going to explode. And your company's name is going to be in a landmark judgment. So you have to be very careful when you draft an arbitration clause. That's the reason I've mentioned handle with care. It has to be handled with care. There are four or five components which are very important, which you should not miss out, or you should not draft it inappropriately. If you do that, then again you have to be defending it in the court of law. So arbitration clause, though small, it's very important. It's very vital. Arbitration agreement, again, as I said, this is a standalone agreement. Arbitration agreement, generally we use lawyers to draft it, but I would suggest that even if you're going to take an agreement on your own and draft it, be very particular to the industry with which you're going to use it, because there are a lot of over-the-counter, off-the-shelf agreements available online. So if you're going to take it and use it, be very careful of which agreement you're using. There are people in the industry, what they do is they'll draft the contract, they get it signed, and at the last minute when the person is going to leave the flight, it's a flight time for his flight to leave, that's the time when we go and include an arbitration clause and we get it signed. That is not how it works. Arbitration nowadays is very important nowadays, because people prefer going for arbitration. So equally, when you enter into a project, you give importance to a contract and agreement. Same weightage has to be given to an arbitration clause, though it is very small. So I keep repeating it because it's very small, but the impact is very great. All right. Then we'll talk about arbitration notice. I've already explained. Then we'll move to arbitral award. There are different. You may ask me, why should I even learn about an award? You're in industry, you're representing a client, whatever it is. If in an arbitral award something important is missing, then you will not be able to go for an appeal. You cannot take the right point and go for an appeal. So even if it is a normal arbitral award, which you think it's just a settlement, it still matters a lot, because in the later stage also it can become a litigation. So always be, even if when you get an award, you should be able to read the award, interpret it, and understand what is there in it. All right. And after that, execution application, again, you should know how it is being executed. For industry people, you may not need it particularly, but you should have knowledge. Overall knowledge is more important. Even when you move from one industry to industry, you go and sit before an interviewer, they will ask you what is an execution application. So you should be able to answer them, to tell them what it is about. And even if you go meet a top management, you should be able to explain to them what is an execution application and how it is being drafted. And even when it is drafted and it is brought to you, last minute drafts are there, which may miss out many particulars. So from the industry, you should be able to point out and say, I have done it. So that's the reason I'm telling you. So when I work in the banking industry, though I am from a law background, still when lawyers make a mistake, I was able to find out and say, no, this are not included. This will go against my bank. So these have to be included. So when they prepare a person for witness, I sit with them and tell them this is what it has to be. So people from the industry, you have product knowledge, you have the knowledge of your industry, you know the technology, you know the technicalities. So this is what is lacking in a lawyer. So the lawyers, they will draft it really well. The language would be really well because we are into it, we are submerged in it. But the technicalities is where you have to look into it and you have to make the changes appropriately. Now coming to types of clauses, these are the different types of clauses. Now before that, I'll tell you what is negotiation, mediation, arbitration. First, A and B get into a contract, they get into agreement, they start the project, they have a controversy, they have a claim. First thing they have to do is go for a negotiation. Again, I tell you, it is not mandatory. Negotiation is where those two parties alone, they sit together and then they come to a compromise. If it doesn't work, then again, mediation is there. Mediation is like one person mediating between two people. So it can be first starts with a joint meeting and then they have a private meeting, all right? So they generally sit in a round table. That's how they say, because if there's an edge, it means there's no equality. When you all sit together, it is like you are all equal. You can share information, you can be free, there's no confidentiality. So that is about mediation. The last one is arbitration. Arbitration, I've explained to you, that is arbitration. Now, as an industry person or as a lawyer, when you're going to advise your client, advise your top management, you need to find out which will suit your client or which will suit your industry. Is it going to be negotiation, arbitration? So negotiation and arbitration will be what? First, you will say, let both parties sit and talk. You'll tell your manager, your top management and say, let both of you sit and talk first. I think this can be amicably resolved. Otherwise, we have to go for arbitration. Okay. So if your management is okay with that, then you can include this clause. This is called as a negotiation arbitration clause. Step clauses. Generally, they call it step clauses or hybrid process, where all these things are put together. Then again, you have mediation arbitration clause. Very interesting because of late there's a lot of controversy because whether mediation arbitration will work or arbitration mediation will work. Med-arb or arb-med, that's a controversy going on. Why? Because in mediation, what they do is, as if I'm sitting there, Hepzibah, I go there, I represent my company, I tell everything confidential about my company. It doesn't work out. Mediation doesn't work out. Then what happens, this person, they go sit as an arbitrator. The same mediator sits as an arbitrator. What he will do, whatever I said as confidential will be in his mind and that will influence on the final award. So in that case, you have to be very careful. So if you're going to tell your top management or your client to use mediation and arbitration clause, you have to be very careful whether it will go against you. All right? Only reason because of the confidentiality. In arbitration, there's nothing confidential, but in mediation, in private meetings, we are going to say whatever is happening without any confidentiality, with confidentiality, you want to tell everything to the mediator. But the mediator might use it against you in the arbitration. And the next one again, negotiation, mediation, arbitration. This is a 3-step clause or multi-step clause. Arbitration, mediation, arbitration. Now you would have understood how it works, Sanofer. And then pre-dispute mediation clause again. Before getting into arbitration, you can say we will only go for mediation. This is a clause, and before that clause, you can include the same. Before going to arbitration, I'll have a Sanofer, and I'll go for a mediation. So these are the different types of clauses. Why I'm so particular about the PPT is because I have given some examples which will be easier for you to understand. But something is not. Sanofer?
Yes, ma'am. Yes, ma'am. Yes, we have presenting the PPT, ma'am. Madhu will present now.
Okay. Let me continue. Let me not waste time. I'll continue.
Please continue.
We will share the slide with you also. Don't worry. So in that same slide, types of clauses, if you see below, I have given an example where it clearly mentions. It's working. Okay.
Your screen is visible, ma'am, now.
Mine is visible anyway. All right. So types of clauses are that if you go to the last part, if you see, I have given an example. So that is how you draft. This is all available online. So don't have to worry. But you have to, what you have to worry about is which clause to use. So if you're going to use a mediation arbitration clause, first you talk about that is what I've marked in red. So you will say we will first try to settle it by mediation. If it doesn't work within 45 days, then I'll go for arbitration. So this is how, I'm sorry, when we go to the multi-step clause, 3-step clause. The first thing I marked in red, negotiation. So I go for negotiation. If it doesn't work within 45 days, I'll go for mediation. And again, if it doesn't work within 45 days, I go for arbitration. This 45 days is not mandatory. These are things that you key in, you draft. So you have to know which is good for you, good for your company, and then draft accordingly. All right, nothing in any of the drafts, acts or rules, nowhere these days are mentioned. This is one I've taken from Saudi Center, where they've given 45 days, 45 days. So you also have to limit it. If you're going to say, if you're going to leave it loose-ended, then it will go on and on and on. The mediation will go, and it will not enter into arbitration at all. So that is the reason they also give a time frame for it. All right, this is about the multi-step clause. Then there are other hybrid process like final offer arbitration. This is also called baseball arbitration. This started, I think, from a baseball players' dispute, labor dispute. So what they will do is, you would have heard of this King Solomon story, where two ladies, they'll bring the baby and they'll say, this is my baby, this is my baby. And then finally King Solomon will say, let us split the baby into two. Yes. So what they will do is, they will split the baby. They will immediately, the true mother will say, no, no, this is my baby. So in the same way, this arbitrator will say, both of you give me a proposal. So this proposal he will receive, and he will look into which is the sensible offer that he'll take up. How does it work? So if it's a sensible offer, which means I will not ask for 5 crores when it is worth 5 lakhs. If I'm going to ask for 5 crores, then that person, arbitrator, will know that it is not sensible. So obviously, 2 of them will come with a sensible offer. This is called the pendulum or baseball arbitration. Project umpire, those in construction industry will be knowing project umpire model. It's been there for almost 30 years. So what is this project umpire model? Again, when you start a project, along with the project, you also appoint a umpire. We don't call him an arbitrator, we call him an umpire. So what the umpire will do is, from the beginning, from the day the contract was signed, and after that, whatever the documents were involved, everything is brought before the umpire, and he knows everything. So once he has a hands-on experience on everything that is happening throughout the project, then when there's a dispute, when there's a controversy, this person comes into play, and then he helps out with the final decision. So this is called the project umpire model, which is used mostly in the construction industry. About the cost of this umpire, this is included in the cost of the project itself. All right, this is all about the preliminary part, what you need to know. Now moving to the main components in an arbitration clause. As I said, it is a atom bomb. This atom bomb has to contain all these 4. First thing, number of arbitrators. So you have to decide whether it's going to be a sole arbitrator, 1 arbitrator, or is it going to be 2 arbitrators. It can't be 2 arbitrators. So again, is it going to be 3 arbitrators? So that is how we have to decide on the number of arbitrators. Number 2, place of arbitration or seat of arbitration. Again, place of arbitration, seat of arbitration, it is either strategic, practical, or legal. All right, strategic in the sense, if you're going to say the place of arbitration is in India and the person is somewhere, or the other party is somewhere in another country, they will find it difficult to come. So instead of traveling down and doing all that, they will get down to negotiation or mediation. All right. So that is strategic. Another thing is practical. That is what you have to do. You have to fix a place of arbitration. Legal, because it requires, your act requires. In everything, if you see Arbitration Act in India, it clearly explains everything what has to be there in an arbitration clause. All right. In some, it is not mentioned. So these are things you have to follow so that you don't get caught in a future litigation. Third thing is language of arbitration. So you have to clearly mention what language you're going to use. Fourth one is governing law. I mentioned about Enka versus Chubb. I am not talking anything legal today. So Enka versus Chubb, if you can go through, you will know the dispute that was regarding governing law. Law as such is either procedural law or substantive law. Right? Procedural law is like, if I say the seat of arbitration is India, then I follow the procedure followed in the Indian jurisdiction. Substantive law is different. In the main contract, if I say it will follow the Russian contract law, then again substantive law will be what? Russian law. But the governing law, if you take, there's a lot of controversies in that. So there's a lot of controversy between seat of arbitration and governing law. So I can talk to you about Indian law, but because there are people from Middle East and other places of the world, I would suggest that you please go through what is the law or what is the practice in your area. All right. So when you are confident on which is the place of arbitration and which is the governing law, which will be easier. So that's the reason I mentioned Enka versus Chuck. If you go through that case, you will understand in UK that's a different judgment. But that we have been following in India for quite a long time. So this is the issue in this 2 and 4. So 1 and 3 is very easy between two of you. 2 and 4 is little legal involvement. So you have to be very careful which place you're going to put a seat of arbitration and then which law you're going to mention as governing law. All right. Now, as I said, after all this slide, you will get to understand that when you have written a well-written dispute resolution clause, you have laid the foundation. So writing an arbitration clause, be it arbitration clause or the arbitration agreement, that lays the foundation. It's like SMs are laying the foundation for me to go forward. So once you've laid the foundation, you also need to know what is a standard clause and what's the custom clause. So standard clause, as I've told you, there are 4 things which you have to include. So apart from that, you mentioned about the capacity and authority of the parties and the language, all of these are then the standard clause. Now talking about custom clause, you go to buy something from the shop, you have a standard, something standard will always be there on the window. But apart from that, you want to customize, you want to name, put your name on that, you want to have some more decorations on that, you ask for a customized. In the same way, clauses also you can customize and provide. Like this, you explain them at the end of the clause, you can explain saying, if it doesn't work, I will go for appeal. That's the appellate process. Then you can also mention it will be a documents only hearing. Why documents only? You can say everything is there on the document, so we will not come for a physical hearing. So the arbitrators will decide based on the documents in hand. All right. Then about the method of arbitrator selection, arbitrator qualifications. So these are all are given in the PPT. So these are customizing your clause. You have a clause, the small clause, and within that you're going to customize and give more information in it. Okay. But there are deadly sins which I will explain in detail later. So these are the things about a standard clause which you will use and a custom clause. Now this is an example I've taken from SIAC clause. This is a SIAC clause where you can see the seat of arbitration is mentioned. And those red things are what I have entered. So you either mention India, Singapore, or whichever country you are in, tribunal 1 or 3, language, English, Spanish, Arabic, it's up to you. And last part, the contract is governed by the laws of that you have to decide. So that is where you talk with your client and explain to them legally. That's a legal aspect. I think either you would have had a webinar before or will be having in the coming days, because governing laws is a chapter I have to talk for 1 hour. So governing laws, you have to be very careful which one you are going to use. All right. Same way for WIPO clause. WIPO, why? Because there are a lot of patent disputes which are going on. So for that, again, WIPO has entered into arbitration. So they also have a standard clause. In that clause, if you see a sole arbitrator I've marked in red or 3 arbitrators, you specify the place, you specify the language, and then you specify the governing law, the jurisdiction. So these are 2 examples that I have pulled out for you to understand about arbitration clause. Now, a recap or your preparation for drafting. So first thing, you collect all the information from the client. You decide on the standard format to be used. The standard format is nothing but the type of clauses that I told you. So you decide whether we're going for negotiation, mediation, arbitration, which one, and then you decide on drafting. And then last, what Sir has said, get well versed in the legal style of drafting. Legal style of drafting is not that difficult. Nobody was born with the legal style of drafting. We all learned it. So it is not that difficult. The more you keep reading drafts, you keep going through agreements, you will easily be able to draft. All right. So even I started 20 years back and I'm able to do, and I've actually got addicted to drafting. So I recommend you to do that. Don'ts. What are the don'ts? See, sometimes we go beyond and we use words which are not required. For the first point, if you see in the first point, if you see, it says the parties shall use all reasonable efforts to amicably resolve the dispute. Now, what are the reasonable efforts? So this can be used by the respondent, the other side, and they can say that we've been using reasonable efforts, we've not come to a conclusion, so we will continue. And good faith is another word. Good faith negotiations. It will keep continuing. It will not end at all. So the other, you're giving a chance for the other party to keep prolonging. Sometimes they call it guerrilla tactics and all. So these are things that you give for the other party and it goes against you. Same, the second point, mediation arbitration clauses, I already said, time frame is important. If you're going to leave mediation open-ended, it will continue for a long time. Third one, permissive versus mandatory wording, may or shall. May or shall is something we teach our students. May is optional. Shall is not like that. Shall is mandatory. So all of us would have heard somewhere in our life about the 10 commandments where it says thou shall not kill, which means what? You shall not kill. It's not that thou may not kill. May not is an option. You may kill or you may not kill. All right, something which you can remember. That's the reason I told you. So it's may is optional, shall is mandatory. So when you use, it's common language. It's a language. English language is not a language. Our mother tongue is different. So may and shall look similar to us. It's a funny language for us. So in all our languages in India, if you see, words are very particular. We don't have such ambiguity. But in English language, there's a lot of ambiguity. Because in may, there's a different meaning behind it. In shall, there's a meaning behind it. So that is why you need to know what should be used in an agreement. Now the fourth one, again, ambiguous. Don't make any conditions in that which is ambiguous, which is not clear. Okay. And then the fifth one, a reference to non-existent institution. Some people do. If there's an institution, refer to it. If there's no such institution, do not refer to any rules which does not apply to arbitration. Sixth point, unworkable time limits. As I told you before, no, mention time limits which is workable. Too much is also not good. Less time is also not good. Something reasonable is required. Failure to include all necessary parties. That is why I said while drafting, you have to collect all information. If there's another party involved, there's a third party involved, or an expert involved, or a witness involved, every information has to be inserted. So you have to specify the right parties. Failure to specify the 4 components that I told you. Provisions that are contrary to the substantive law. So if you're going to choose one law, if you're going to choose Indian law or you're going to choose Australian law, you have to stick on to it. You should not say something which is contrary to the law that you have chosen, the governing law that you have chosen. All right. Now moving to arbitration agreement. What are the main components? See, arbitration clause, whatever I have said, that is the foundation. From that, you're going to take some bricks and fit it into this arbitration agreement. That is all. Only thing is that is very short, this is very long. And it is going to be a little detailed. The first thing, seat of arbitration, I've already explained to you. You have to mention in an agreement. I'm showing you an sample also, format also. So don't worry. It's going to be seat of arbitration, then procedure for appointment of arbitrators. The first slide I told you. Language of arbitration, the governing law, type of arbitration. This is something I did not talk about. It is either domestic arbitration or an international arbitration, all right? Or ad hoc arbitration or institutional arbitration. If it's domestic, we all know domestic, within India, within your own place. International, between 2 territories. And if it's going to be another type, it's ad hoc, where the party themselves decide on the arbitration and they proceed with it. If it's going to be an institutional arbitration, you involve, as I said in the first slide, HKIAC or SCIAC or similar such institutions, we involve them to help us out. All right. Number and qualification of arbitrators, all these you can explain in detail in an agreement. There are some restrictions, I will tell you. Name and address of the arbitration institution should be mentioned. And then finally, binding clause. Binding clause is from the industry, we may not know, binding clause is something like binds together. So when I agree to the agreement, I'm bound to follow it. That's it. So 2 papers you stick together, it gets bound, right? So the same logic. So when I agree to the agreement, it means that if an award is passed, then I have to follow it. So for format, this is the format. So clause I showed you 1 paragraph, but an atom bomb, but this arbitration agreement, you can include as many details as you want, but precisely not too much also. So what is that not too much? That is what I'm going to talk about. Avoiding 7 Deadly Sins by John M. Townsend is a very good book, but I've only taken the headings and I'm explaining to you. Equivocation. What is equivocation? Ambiguous language to conceal the truth. So you know what is the truth. Just to conceal it, what you will do is you will use ambiguous language. Ambiguous is not clear language. You will think that if you jumble words and you draft a clause, then you can conceal the truth. That doesn't work like that. The truth will come out. All right. Inattention. What is inattention? In modern days, we say something called cut, copy, paste. As I said, last minute, when the boss is leaving, you add something, go sign, get it signed, then you will get into a problem. So you have to be very attentive in what are the things that you're incorporating in a clause and also in an agreement. All right. Omission. Omission again, if you omit something, As I said, the 4 components are very important. If you omit something, for example, you're not mentioning governing law, what will happen? Like in cover system. So you have to be very careful on that. Over specificity. Specificity in the sense you mention everything. This arbitrator should know this language. This arbitrator has to be an expert in law with such and such a degree, such an experience. So much if you're going to specify, again, you will not get an arbitrator. So over specificity is also a problem. Unrealistic expectations. So you are not real in what you are expecting. You're going to say within 3 days, I will appoint arbitrator. Within 3 days, another 3 days, the third arbitrator has to be appointed. Within 7 days, hearing. Within 2 days, award. Doesn't work like that. These are unrealistic expectations that you should not have. Very realistic you have to be. Litigation envy. Sometimes this is the problem with lawyers. So what they do is they are so involved in litigation that arbitration litigation become, go hand in hand for them. What they say is whatever has been awarded, that has to be scrutinized by your judiciary. So these are things which we have to avoid. This is different, that is different. This is almost like corporate culture, that is almost like judicial culture. So you have to differentiate both. You should not have that belonging towards your litigation field. Overreaching. Overreaching is also not good. You try to mention too many things which is not required. You reach out beyond what is required. Again, overreaching is found in many people who are initial drafters, who are in the initial stage of drafters. For example, in case of labor disputes and all, what they do is they will say the company is allowed to record the arbitration, but the employee cannot record the arbitration. So that cannot be like that. You cannot be one-sided or biased, or you cannot show that you are drafting, you have drafted for your own company. So that is overreaching. You have to be very particular on all these 7 things. These John calls it as 7 deadly sins. Actually, if you follow this, you can draft a very good arbitration agreement or an arbitration clause. Just a recap: main contract, as you all know, between 2 parties, and that if there's going to be a small clause, that is called the arbitration clause. And if it's going to be a standalone agreement, it's an arbitration agreement. This will be very useful for everyone, lawyers from the industry or all the students. It will be very helpful. So after this, we will move on to notice of arbitration. Notice of arbitration, it is technical as well as strategy. Why do I give a notice of arbitration? First thing, there's a process, so I have to give a notice of arbitration. Well said, good. But there should be strategy behind it. There is a strategy behind it. Why? You give pressure on the other side to resolve the dispute. All right. So there's an ongoing dispute between 2 parties. So they both want to resolve it, but it's not going to happen. And the other person is very adamant. You want them to bring them down to their knees. What do? You send a notice of arbitration. So that party will decide, okay, it's going to prolong. Let me not continue. But there are possibilities. They might even. There are situations where they will reply back and the arbitration will go on. But this is a strategy that is used. Sometimes it works. All right. So you also need to know some strategies. Technicalities, yes, or you give the notice of arbitration as per the act so that the other person knows. You fix the date. You also mention about the arbitration clause or arbitration agreement that you entered into while you entered into a contract. So all that you mention and you give a notice of arbitration. So when you give this notice, what are the things that are the main components or main things that you have to remember? The first thing, your reference to an arbitration. So you clearly refer that through this notice, you're going to refer to an arbitration. After that, you give the details of the parties, both the parties' details, and then you refer to the arbitration clause or the arbitration agreement which both the parties drafted. And after that, you will give a brief statement of the dispute. Whatever is the dispute between the 2 parties, you mention in a brief statement. After that, you go to the conduct of the arbitration. Conduct of the arbitration, nothing but the arbitrators involved. How many arbitrators you're going to involve in this? All those details will be mentioned there. Tribunal details, and then you go for the relief or remedy claim. This is the sequence. What is the sequence? Why should we maintain the sequence? It is also called the style of drafting. So when a person reads it, they will understand in the sequence what is happening, what is going to happen, what will happen, everything. Was and everything. So it's like in most of you are from India, so you will know, right? When you go for a wedding, Indian weddings, they usually keep food in a particular order. Otherwise, it becomes a very deadly sin actually. So in that same way, you have to keep it in a particular order so it becomes pleasing to the eyes. It becomes easy for people to understand. So that's the different headings which you have to follow. All right. Now next, what will this notice do? This notice will invoke the arbitration clause. You have written an arbitration clause. You have entered into an arbitration agreement. But something has to invoke it, right? Something has to light the fire. The fire is there, you have to, the candle is there, you have to light it. So that is what this notice will do. It will light it so that the proceeding will start to happen. So that is what I have mentioned here. And then clearly, if you go below, I'm not talking about India. I know there are people from other countries also. No legal today. So if you go below, there are 5 points I have mentioned. Okay, so you have to mention the intention of the sender. So my intention is that I want to settle, I want this claim amount. So I mention the intention. Then I specify the contract. Specifying the contract is like A and B company might have different contracts, not just one contract, right? So people from industry will know. I might buy too many things from one person. So you have to specifically mention which contract it talks about. Then you record compliance with precondition for invocation. So before invoking, you would have gone for some precondition like negotiation, you would have mentioned mediation. So you will say, see, we tried negotiation, it didn't work. So I am calling for arbitration. So that's a third point. Fourth point, you call the other party for a meeting. So all this I have marked in red. So you call them for a meeting and then you say, I have nominated Sanofer as my arbitrator. So the other party will know, okay, so this person has nominated this person. So when you say that, it is more easier because when they reply back, they might even say, I will not agree with this arbitrator, or they might come back saying, since you have nominated this person, I am nominating so and so. So it makes work easier for you. All right. So this is about the conditions, and then you go for the requirements. Okay. What is required for a notice? There should be an arbitral clause in the contract or an arbitration agreement. All right. So this is where, because you cannot send a notice without an arbitration agreement or arbitration clause. But there is one possibility where we call the submission agreement. So after you enter into a contract and the work is going on, there's a controversy and you want to resolve it through arbitration, though you don't have an arbitration clause or an arbitration agreement, at that point of time, you both can, A and B can enter into a submission agreement and say, we will enter into a arbitration agreement. So that part is also there. And then there should be a dispute. These are all preconditions that should be there. There should be a dispute between the parties. And then in multi-tier arbitration, the steps preceding invocation. As I said, the multi-steps that I've said. So all those should have been followed. Mediation, negotiation, or mediation should have been followed. So this is a requirement before you send out a notice. Checklist. What is the checklist? So checklist, this is especially for government. I'm happy that Sir talked about government because a lot of things are happening in government where they prefer going for arbitration nowadays. Now, when it comes to government, at least in company side and corporate, you have the liberty to draft your own arbitration agreement and you might even miss out. That's okay, fine. But in government, it's not like that. There are a lot of vetting process through which it goes through. So there are particulars which you have to be very careful, eligibility criteria. So people working in the public sector will know. Even when you go for a work, there's a vacancy announced, all these details will be there. They're very particular in what is the requirement. So in a corporate company, when you go for, they will not tell you what is the remuneration, right? Only after you go there, you bargain all that. But in government, it's not like that. Everything is clearly mentioned. There is no loose ends in that. So in the same way, you have to mention eligibility criteria, experience, what are the payment terms, methodology for empanelment. Here in arbitration, even though it is arbitration in government, you have to empanel. So what is the methodology that is used? Duties and responsibilities of arbitrators. All right. So for example, if it is any other case, if it's a high court judge or anybody, they all get their powers from something, like they get their powers from an act. Same way, duties from the constitution. In the same way, duties and responsibilities of arbitrators. Where do they get it? They can get it only from the agreement that you draft. It is like you give them a responsibility, you give them a duty to do. All right. And the terms and conditions regarding award. So that also in government especially you have to mention. Sometimes people ask for recent decision. Mostly it is a recent decision. Sometimes they say it's okay, we just need the amount and details. Very simple draft. So The terms and conditions have to be mentioned. Now moving on to international arbitration. So we talked about a notice in domestic arbitration. What about international arbitration? It's the same. These are the terms that are used. The first thing, name and description. Again, you mentioned claimant, who's a claimant, who's a respondent. And then you go to the parties' contractual relationship. So you mentioned what is the factual background. Okay. Then you go to what is the claim, legal basis of claim, on what basis you're asking for a claim. Okay, generally they say it is not one of the parties breaking the law. It is rather one of the parties misinterpreting the contract. Here, if you see in arbitration, there's nothing of breaking the law. Some contract is there. There is some misinterpretation, some misunderstanding, some controversy. So that is what is the claim legal basis that you have to mention here. Respondent's violation. If there is any violation, that will come under this. Then dispute resolution clauses. So arbitration clause you will mention, or the arbitration agreement. You mention about the place of arbitration, governing law, language. And after that, you go to the arbitral tribunal. How do you constitute it? All of those details. Then you go to the claimant's damages. What is the damage that you are asking from the other party? And then you go to the statement of the relief that you seek from the other party. Relief is nothing but what are you expecting from them to do? That is the relief. So this is with regard to international arbitration. The style alone differs. Domestic and international, if you see, the style alone will differ. Okay. So here the headings I've shown. Here it is domestic. It is very plain, straightforward. In international, a little complicated, not complicated. The wordings are a little higher. That's it. Next, we'll move on to interim applications during arbitration. What is this interim application? As I said, after this, it is all about legal thing to do, but interim applications fall under Section 9 of the Arbitration Act, where if there is any disputed property, and that is the subject matter of the dispute which you are handling in arbitration. So what you will do is, you will apply for interim relief. You will say, I want to preserve it. I want to restrain some breach of contract. Or things like I want to restore the status quo, I want to preserve the evidence that is inside it. So all these things follow. It also comes under the UNCITRAL law. That's the reason I mentioned. And point number 5, UNCITRAL also talks about it. So interim applications are similar to our IAs that are applied in CPC. So there are two things: ant and pillar order. Another one is Mareva injection. This is for people from abroad who are in this audience. So ant and pillar order is nothing but you want entry into some place which is under arbitration. This is the injection that you ask for. Mareva injection, you prevent somebody from entering into it. That is Mareva injection. All right. So in all of this, code has wide powers. In 2020, this judgment was given. I've given the detail also. You can refer it. So the court says it has wide powers. I can give an interim injunction when the party approaches me. So this is about the interim application. Then we move on to arbitral award. Hope I'm audible and I'm clear in whatever I've taken till now. So I move on to arbitral award. Arbitral award, these are the things which have to be in an arbitral award. The addresses of the awardee, or whatever is the address, the party's address, the arbitration institution's address, the state court's address, all of those details. Timing and structure, again, you have to mention clearly there is something called procedural order. So every procedure that is followed, they will issue something called as the procedural order. This procedural order is issued by the arbitrators. So when they draft an arbitral award, they also have to include all these details. Just like, suppose you're asked to write something about an annual general meeting, there's an AGM meeting, and they ask you to give the minutes of the meeting, you collate everything and send. The same way, from the beginning, from the start till the end, they draft everything. People from law background will know because they have been reading through landmark judgments and other judgments. So this is what is about the structure of the award. And going to the length of the award, length again, it will have all the exhibits and authorities. So if there is no exhibits, no authorities, length will be very short. There are one-page award also. If there are a lot of exhibits, like in a technical field, there you have a lot of exhibits, lot of tables, lot of percentage, everything involved. So the length of the award will be more. Diagrams and all will be there. Finally, recent decision, as I told you, sometimes we ask for the parties will say we don't need a recent decision. It's enough if you give us the award, the cost involved. But sometimes, most of the times, we want it to be detailed, recent decision. We also study in administrative law. So we give a recent decision of what is the award that is given. So you have to be in detail. This will be in detail. So what is this? What is the use of the people from the profession or from the corporate or from the industry who want to know from arbitral award is you need to know how to read an award. Language doesn't matter. You need to know the particulars. These are the particulars which has to be there. Okay, so you need to get from the client in the beginning itself what are the vital information that are required in the award, final award. So that is how when some information is left out, you can go back to the in Arbitration Act we have. So you can go back and you ask them to amend. You can ask them to amend the award, not on the part of the decision, but on the part of the particulars of the award. All right. So that is where your role plays. So when you receive an award, you have to find out if anything is missing. If in case of law, application of law and other things, your lawyer will take care of it. In the question of law will be taken care of. The question of fact, because I worked in bank, because when I deal with credit cards and I talk about the operational part of it, when I talk about wealth management, the advocates will not understand. Reason why they are into litigation, they are not into your product. They do not know your product knowledge. So the fact part of it, you should be able to explain. Even if in the award, the arbitrator has concluded the fact, he has not understood the fact properly, it is your duty to explain to them. All right. So this is about efficient drafting of arbitral award. Now drafting and execution application, again, e-applications, it's similar. These are some few points which should not be missed out. SM sir has already pointed out how if an appeal is not filed properly, the previous applications are not properly filed, then you will lose out on that. Okay, so the contents, the number of suit is important. Name of the parties, date of decree. Decree is nothing but judgment for people who don't know. Judgment is what we call as decree. And we also need to know whether any appeal was filed, and you give the amount along with interest and against whom the execution is sought, the other party. So these are the details very important for drafting an execution application. Then last two slides, just a recap and how you have to get information from the clients. These are very important things that I've been telling from the beginning. You talk about fees and expenses. First thing, fees and expenses. If you're in industry, you have to tell your boss or your management what will be the fees involved. All right. If you're going to involve SIAC, then you're going to pay in Singapore dollars, which will cost you a lot. So you have to talk to them and tell them, boss, this is what is going to happen. You're going to spend so much millions on it. Is it worth it? Can we go for negotiation? This is about discussing with clients, but you can also take it as discussing with your company management, and about arbitrators or experts that will be involved. So you will also explain to them on that. ADR options. So I told you about different options available. So you need to find out which will suit your client and accordingly explain to them, right? Timing is very important, especially when you're in a project. We all know projects are time bound. So if you're going to drag it by way of arbitration, when your project is not completed, you're going to lose millions of money. So timing is very important. Location, again, we've gone through location many times. So you need to be very particular on location, confidentiality. Off late, no arbitration. Arbitration, we cannot enter into an arbitration and watch it. Even students are not allowed to watch it. That is very pathetic because they don't get to know what is happening inside. But confidentiality is maintained. But one thing you have to be very clear, if there is an arbitration going on, people will get to know. Only things they will not know what is happening inside. So when you advise your client, you have to tell them, we cannot hide it. This is something which will come in the newspaper that we cannot hide. What is happening inside, that is up to you. You can make it confidential. All right. Then controversy, claim, dispute. Throughout, I've been using the words controversy, claim, dispute. So if you see all these commercial, construction, international, healthcare, employment, labor, patent, in all of this, these words controversy, claim, disputes will be used interchangeably. So you can use all these words. But when it comes to labor and patent, you use the word dispute. Right? Labor is generally dispute only. Patent again is only dispute. This is where the choice of words is important. If it's related to some other employment related, if it's not a dispute, it's a general employment related thing, then you can say it's a controversy or a claim. But when it is a dispute, proper dispute between an employer and employee, we always call it a labor dispute. All right. And again, for patent, again, it is always a dispute only. It's not a controversy. All right. So this is all about drafting, I think I finished on time. All right, so you can always reach me at this email ID. I'm available always, and also in LinkedIn. And anything else I missed out, Madhu? Madhu, are you there?
Yes, ma'am. Can you hear me? Am I audible?
Yes. Yes, I just want to thank Ram sir for giving me this opportunity. I thank Madhu, Sanofer, and of course Soundarya, and also SM sir for this wonderful session. I hope it was useful, and I will share the PPT as well. Anything else you want me to take, Madhu?
No, ma'am. No, ma'am.
Because I know it's time because sir completed 5:40. I didn't want to take too much of your time. So I've completed on time. If anything, you want any details, you can always reach me at my Gmail ID or LinkedIn.
Yes, ma'am. Yes, ma'am. Thank you so much, ma'am, for the wonderful presentation.
Thank you.
You have managed to give a feast in a very short time, ma'am. We are very much indebted to you for your time and efforts.
Thank you so much.
Since it's time, the attendees who have posted their questions in chat box, we will answer in our group. We'll move on to vote of thanks. Distinguished speakers, respected dignitaries, and dear participants, on behalf of Bureau for the Empowerment of Arbitration and Mediation, I, Madhumitra, take this opportunity to propose a vote of thanks. At the outset, I thank our keynote speaker, Mr. S.M. Balakrishnan, for giving an excellent coverage to the topic drafting in legal and arbitration. Sir has sown the seed of hope and confidence among the young minds. We are really enlightened with your knowledge and presence, sir. I extend our hearty thanks to Professor Mrs. Hepzibah Beulah for the erudite explanation on drafting in arbitration. Thank you so much, ma'am. We are inspired by your great words. Thank you, ma'am. Last but not the least, I thank all our attendees for the support and presence towards the entire session. And we are glad to announce our next webinar. The topic is MSME Act. We will share the webinar details very soon. Thank you, everyone, and see you soon in our next webinar.
Thank you, Ramsa. Thank you, everyone.
Thank you all.
Thank you, one and all. Thank you, one and all. Very good session.
Thank you so much, sir. Thank you.
Thank you. Thank you.
Thank you very much. Thank you.
Yana.
Hello? Hello? हम्म हम्म अरे मैसेज कैसे भेजूँ हम यहाँ? साला जियो भी ऐसी कल छुट्टी है। हम्म नहीं नहीं ना काली पिया है। हम तो नहीं। नहीं 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 दारू तो हम नहीं पीऊंगा। कसम खा लिया।
Sir? Hello, sir? Sir? Hello, sir. இருக்கீங்களா சார்? சார்? சார் இருக்கீங்களா? சார்? ஹலோ
ஹலோ சந்தீப், சந்தீப் தம்பி, ஹலோ ஹலோ
ராஜேந்திரன் யாரும் பேச
இது
மாட்டாங்க. ராஜேந்திரன் ஏன் தெரியுது? ராஜேந்திரன் சார் லைன்ல இல்லைன்னு
நில்லு
நினைக்கிறேன்.
பாக்கேன், இது மெசேஜ் வந்து கிடக்கான்னு பாக்கேன். ஆமாடா, மெசேஜ் யாருக்கும் முன்னால வந்த மெசேஜ் தான் இல்லடா. நில்லு பாக்கேன், ஏதாவது செட்டிங்ல ஏதாவது
எனக்கு உன்னோட மெசேஜ் நான் யூஸ் பண்ணலாமா?
இல்ல எனக்கு அது எனக்கு வந்துருந்தாலும் ஒன்னு இது பண்ணி இல்ல வரேன். ஒரே நிமிஷம் வரேன்டா.
ஓகே ராஜேந்திரன்.
அப்படியே இல்ல வரேன். வரேன். திருமா
சொல்லு ராஜேந்திரன். ராஜேந்திரன் ஹலோ ராஜேந்திரன் இருக்கீங்களா? ராஜேந்திரன் ராஜேந்திரன்